So, item 1.
This appeal was initially listed before the division bench. Then this is listed before the single bench. Today I think one mistake probably.
No, matter will come here.
Here. Notification says my lord.
No, it was by the district judge.
Yes,
So
sir.
it should come to the single
Single
bench.
bench. Yes, I got the notification. It came. It was last time it came. No order was passed.
No, you are right. There's the notification.
Lordship it takes.
Because now we have divided it. The family courts will go to division bench and the regular appeals will come to district judge will
Actually,
come.
my lord, that's for why no curiosity, my lord. Why it was like that, my lord? Because why it like that, my lord? It was
No, you see, at that point of time, maybe the collective wisdom was that both appeals should be treated equally. But now you see, there's a because otherwise there's a mandate in the Family Courts Act 1984 that it should be taken by a division bench. That mandate is not there in the civil court.
my question. What the object of that will be, my lord? Because ultimately, it is not. I understood what it mean actually.
Here, my lord, I am the respondent.
But we have to abide by this notification.
Yes, ma'am. Yes, yes.
This Mr. Harbisa M. Nath, Senior Counsel, Assistant Witness A, but Senior Counsel for the appellant, and Mr. M. U. Ahmed, Counsel for the respondent. Next paragraph is MAP TV is preferred against the judgment and decree dated 5/9/2017 passed by the London District Judge Dibrugarh in TS within bracket M number 6 of 2014. Next paragraph. It has been brought to the notice of the court that while notification number 30 dated 21/3/2023, matrimonial appeals other than the family courts are required to be listed before the bench of Honorable Single Judge within bracket Civil Bench 1. According to the registration shall examine and list the matter before the appropriate bench. You want some date for the matter?
Well, here, my lord, one thing is we allow me to listen.
Definitely.
The respondent earlier appeal 22/6/2023 that is award of amount of 2 lakhs to be deposited before the 22nd of the August. That has been deposited by the respondent side.
Okay.
The receipt of the already received the amount by we will say.
Okay.
He is appearing for personal appeal, not personally now. He may be dispensed if it is not equal.
Okay. Just a moment.
My lord. Probably the order should be passed by the
No, because your party is present. He wants dispensation of personal appearance. I think personal appearance has not been ordered. There is no order of personal appearance.
Because what happened? Last 2-3 occasions, nobody appeared on this side.
Oh,
Neither
I see.
counsel nor anybody. So she was compared to person.
Oh, okay. Yes, ma'am. The Honorable Counsel for the petitioner submits. It was sorry, the respondent submits. Respondent number 1 submits that, as the said as the respondent number 1 was not represented. This court, the order dated 16/5/2023, had directed the respondent number 1 to be personally present. He praised that the personal appearance of the petitioner be dispensed with. Next. As the Learned single judge will have the jurisdiction to pass on this. The said prayer be renewed on the next date of the same. Nonetheless, respondent number 1 was personally present in court today. For the day his personal appearance is dismissed.
Now today is like a hearing and done. But rather than they are not filing the appeal, you are the limitation. You are filing the
So that you'll have to argue. If that is so, you'll have to argue before the honorable single judge. That submission may be made. Huh?
Before the appeal court, when the matter comes on next.
Apparently, as per the registry's note, it's not barred by limitation. You can have a look. There's the. This has been considered. It appears that it has been considered. Look at the. No, you can make note it.
8/1/2018 they have filed it. You know,
No,
after 4 months.
That may be there. You just check it out. You can note it down because you see, Mr. Ahmed, we would not deny you the pleasure of using the calculator. You just note the dates in your diary and you can have the pleasure of spending time on your calculator.
Initially, my lord, my senior Mr. Mahindra. Whenever this type of case comes, my lord, you know how to calculate the date. Then he said, remember, always count first year and the third year. And then he should teach us.
No, but you see, as a when it comes to the registry, they calculate it backwards. But as a lawyer, we also always calculate it in the state.
Then you add it.
And then registry will do it backwards, and then it's okay.
Ultimately, should be.
So you need the prayer on the next date, Mr. Ahmed. Here, motivation. Both sides express some urgency in the matter. Just to the next. I said list in the next slide. Mr. Nath and Mr. Ahmed, in this matrimonial this appeal, there is no chance of what you call mediation. It is unlikely to be positive.
The only question is, the court has given it 2 lakhs micro. Now, how much security offer? This is the only question. 1 lakh.
The petition filed for diversification by the applicant. That will be allowed.
So that's what I'm asking. Since it's a matrimonial matter, we are asking you, is there any what do you call chance?
Quantum, how much will be included? That is the question. Because it was secondary, this concealed that fact. In the evidence, everything came openly and admitted. Yes, it was. There's going to grown up Samus. In Chennai, he did it. And the suddenly this is the letter one day from the wife in his name. Then it was found that in the second wife.
No,
Now, life is
even-
spoiled, totally life is spoiled.
Even if it is a dispute on quantum, it can be settled.
This one, my lordship like.
So you can take you can take instructions, Mr. Bhattacharya, you can take instructions and come back. We can send it to mediation. From the appellant, you take telephonic instructions. Come back after some time. If it is there, if it can be sent to mediation, we'll.
Go ahead and put it on the. Directly not.
Okay. Because we have, when I saw Mr. That I thought that he would be the best negotiator.
In this case, but in some detail.
Huh. Because he has a very polite way of enforcing his views on us. So if you can persuade us, I think we can also persuade both of your parties.
Marshal Noel is a respondent minor. He is now working in the pharmacy matter. Pharmacy, there will be limited. He has no issue.
On merit, lordship is passed.
No, no,
That is not merit, my lord.
that we are not
Merit.
exploring it right now. But yes, if it can be, there can be a negotiation, you can.
I don't think because the see, who is a person pharmacy, and the life of that lady has been to destroyed. Consider that fact, what merit, and the DQ diagnosis fight on the section. Now, where she how will it enter life left, like how much money should get? If I would merit, should be allowed. This is something. It's better to go merit like that.
Well,
Yes, Mr. Udi.
Or spend money, right? If you have a list of
Yes.
Where on it is registered, you to use that to four of books. Condition is also the same. Occurrence might not 14 at around 1 p.
Just a moment. No, it's okay. Just a moment.
There is a debt reference attached to it. Debt reference confirmation is attached to it.
Just give us 5 minutes. Before we begin, Ms. Jana and Mr. Abdul, what would be the appropriate way? Number one, we can hear the debt reference first, or we hear your appeal first. Which is the appropriate way?
That preference is only against sentence. My appeal is against sentence and conviction.
So we should hear you first.
Debt
This is my
reference
answer.
lordship will go into the conviction as well.
And as far as Supreme
No,
Court,
that's
But
right.
the fact is, debt reference, if your lordship hears the debt reference first, and lordship decides that it can be upheld, then the criminal appeal goes. But criminal, the applicant has a right to be heard.
That reference will come. in
So
my
I
own
think that
submission.
will delay.
No, he's right. His submission is very short and simple. That death reference is only against sentence. So that way, I think Mr. Uddin has made a point. So we hear the
Amicus curiae is
Appeal.
also there. In
Okay.
view of the Honorable Supreme Court's order.
okay.
Mr. Mohanty is there.
I've given my list of.
Yes, we have it.
We have to one.
We have it.
The date of occurrence 14/3/18 at around 1 p.m. FIR was lodged on 14/3/18 at 8 p.m. Appellant was apprehended on 15/3/18. And since then, he is never allowed to go. He was produced before magistrate on 16/3/18 and remanded to finish at 5. Leading to discovery there as a matter was made on 17/3/18. Charge sheet submitted on 11/6/18. This was committed for trial on 14/6/18. Charge frame on 20/6/18. These are the important dates, madam.
You are waiting for respondent? Private respondent? Okay.
Now I let here before I start on the one, there are two informative. Two, one on the basis of past information given on telephone matter. UPNP was made and police inspection. Subsequently, FIR was filed on the basis of the mistakes of it. Now I let company manager is high.
Yes.
Page 5 is the other. Page 6 matter relevant portion. Sir, I have the honor to state that on the day of occurrence, my neighbor Rajendra Ryam and I were in house repairing work. After the school hour, my two nieces, namely Vishnupriya Ryam, 7 years, and Debarun Ryam, 5 years, daughter of Mukta Joy Ryam, returned to their house. And upon noticing my another niece, Kimi Rum Ryam, 13 years, lying dead with cut on her neck when they raised a hill and cried, I, along with my companion, rushed towards the place of occurrence and show the accused armed with a blood-stained dog running away from the place of occurrence, and on arrival at the place of occurrence, I found my niece lying dead with cut on her neck. My elder brother had gone to harvest June cultivation, and after calling him home, police was informed of the matter over phone. It is worth mentioning that upon noticing the accused running away with blood-stained dog in his hand and finding my niece lying there with cut on her neck, I firmly believe that the accused, finding my niece alone in the house, committed rape on her, and in order to conceal evidence, he killed her by cutting her neck. Finding no other alternative, I have approached the police station to inform about the heinous crime committed by the accused. Therefore, I do hereby honestly pray to your officer to be kind enough to investigate. So this is the FIR. Admittedly, in this case, my lord, there is no eyewitness to the offense. The entire case is based on circumstances.
Oh, what was the age of the deceased?
13 years as per FIR.
Yes.
Then page 8, my lord, charge was framed under 3 head. 376 IPC, first, second, 302 IPC, and thirdly, section 4 of the POCSO. Page 9 committed assault. Page started altogether 21 number of witnesses examined. And it starts from page 10. Now, may I recommend one by one. CW1, Madhu Chandra Ryan.
Yes.
I know the accused Jashimuddin, and we are from the same village. Our residence is on the top of Hillock, and the residence of accused on the plain area. The deceased Inirian Kimi Rung Liang is my niece, aged about 12-13 years. On 14/3/18, at the relevant time, the father of the deceased went for June cultivation. Her mother and elder sister of the deceased, namely Mayavati and Joli Rung Liang, respectively, also went to a rice mill for husking petting. The younger sister of the deceased, namely Vishnupriya Liang and Devarun Liang, went to school. At that time, I and my cousin Rajendra were on the roof of my house for repairing works. As I was on the roof of my house, I saw the house of deceased therefrom. The distance between my house and the house of the deceased is around 20 miles in the same area. While I was on the roof of my house at about 1 p.m., I saw the accused Hoshimuddin going towards east of the house of the deceased through a small pot known as Judy, and there was a dove in his hand having blood stains. But I never thought of committing such an incident. I thought the accused might have cut any cow or anything else. After about 2-3 minutes, the two younger sisters of the deceased were running home from school. Then they started raising hue and cry, calling me. Immediately I rushed to the house of the deceased and found her lying on the ground in a pool of blood with cut short injury. Her upper dress was almost open. There was thick white at her breast. The panty was found in the lower part of her neck, and there was a dress-like skirt covering her lower part of her body from waist. All seeing the same, I became puzzled. Then I also raised hue and cry. I also told my niece Anjali Riyan to inform the parent of the deceased through her mobile phone. Thereafter, the parent of the deceased, along with other police was informed by one Abdul. Police came and took the sample of blood and took the dead body to the civil hospital. Hyderabad. Since the father of the deceased was busy in the funeral right, I lodged the FIR. Actually, one is the said FIR. 211 with my signature. Before 3-4 months of the occurrence, the accused attempted to commit rape on Kanchirong Riyan, my related sister, and for that a case was lost and the accused was in jail for 3 months in connection with that case. After releasing from jail, the accused also attempted to edit with the elder sister of the deceased, namely Joli Riyan. While she was returning home from June cultivation, but when she went down, the accused left her. The material agreed 1 is the said down, material agreed 2 is the 20 having blood state, material agreed 3 is the container containing cotton by which blood was collected from the place of occurrence. Pros. I am an illiterate person. I can write my name only. I cannot say today's date. There is a pot to the south of my house, at a distance of about 12 miles from my house. The house of Surendra Riyan is situated. It is not a fact that Surendra Riyan sells country liquor and his daughter Anjali runs the business and all the terrorists consume liquor in his said house. I do not know whether police arrested terrorists from our village. To the southeast corner of my house, the house of the deceased is situated. It is not a fact that the house of deceased is around half kilometer far from my house. The people use the pot for going to June cultivation. The people of Muslim community also use the pot. It is not a fact that there is a dispute even in regard to the ousting of Muslim people from the village. The house of accused is around 750 meters from my house. It is not a fact that the house of accused is at a distance of 2 kilometers from my house. After hearing him and cry of my niece, at first I went to the place of occurrence. After me, Anjali and his brother came to the place of occurrence. The parent of the deceased came after half an hour along with them. Neighboring people came there. Muslim and Ryan community people gathered there. The accused person is having three brothers, namely Alamuddin, Shahabuddin, and Shalimuddin. I did not see the accused and his three brothers in the place of occurrence along with another person. They appeared after hearing the hue and cry. It is not a fact that the gathered people, including the accused and his brother, found one cow lying near the dead body of the deceased. Then I and Anjali removed the dog from that place. Police appeared at dusk. It is not a fact that when police came and asked us about the incident, we stated that some unknown person had killed the deceased. People from many organizations also came to the place of occurrence. It is not a fact that on being instigated by the said organization, I lodged the FIR implicating the accused person. After the incident, many organizations started protest. It is not a fact that I have stated falsely that I saw the accused going with a blood-stained gown. The deceased was studying in class 5 or 6 in the village school, and on the 11th day, she did not go to school. It is not a fact that there was a very small cut injury on the neck of the deceased. It is not a fact that I did not state before police that there was teeth bite on the breast of the deceased. It is not a fact that the accused person is a very aged person in the locality and the young people do not like him. It is not a fact that out of grudge of land dispute, we young people implicated him in false case. Even earlier, it is not a fact that I did not state before police that the penalty was found in the lower part of the leg, and I have stated the same falsely before this court. I stated before police all this fact, but police did not record the same, and in the event, what is my fault? I know the accused Jashimuddin. I also know the informant. On 14/3/18, I was Panchayat member of Ilarbak Jalanchara GP of group number 1, and on that day while I was returning from Darmuk market, I was reported by one lady of Bechara village that one girl named Kini Rumriang, daughter of Muktaja Riang, was killed. Thereafter, after dusk, I went there and found police of Jamila Al-Sur present there. I found the dead body of the girl found lying on the floor of the house, and there was cut injury at her neck. There was blood below the dead body. Police took my signature on a paper. Exhibit 2 is the said paper in which my signature is appeared, and Exhibit 2(1) is my signature. 3, 4, 5, and 6 are the photograph of the deceased. Cross. It is not a fact that declared hostile. I stated before the police that in my presence, police collected blood from below the dead body with a piece of cotton and sealed the same, and thereafter I put my signature in the cylinder. I heard that accused machine Putin had killed the guard. It is not a fact that to state the accused, I have deposed false. This is my prosecution. Now my defense matter. At around 9 p.m., my signature was taken on the paper. My statement was not recorded by police. I am unable to recall whether police took my signature on black paper or not. In the village lecturer, Muslim and young community people decide. Muslim population is higher than the young population. On the next day, several organizations hesitate protest before reaching the place of occurrence. I came to know that the accused Jashimuddin had killed the girl. It is not a fact that I had deposed falsely that I came to know that the accused Jasimuddin had illegal. I, including various organizations, made attempt to hand over the accused to police since he has committed the incident. It is not a fact that the village people out of fear handed over the accused to police. There was no possibility of disturbing communal harmony amongst people of that area. The photographs were taken from the spot. EW3 Kananta Riyam. I know the accused, Jasimuddin. He is from my village. His house is around 50 meters far from my house. My house and the house of accused are on the plain area. The house of informant Madhu Chandra and the deceased are on the top of the hill. On 14th April at about 1:30 p.m., my nephew Dilip Kumar Riyan came to me and told that someone had killed Kimi Riyan by cutting her throat. At that time, the mother and sister of deceased were in my house for asking Betty. On the same day, at around 10:30, 11 a.m., I was returning from the house of my maternal uncle, Joberairia.